This session will discuss the federal anti-kickback statute, including recent legislative initiatives, case law developments, and significant settlements. The federal anti-kickback statute, or anti-kickback law, is a broadly drafted criminal statute that forbids the receipt or payment of anything of value to induce the referral of federal health care program business. The prohibited remuneration, that is, the kickback, can be either in cash or in kind. Drug and device manufacturers can face liability under the anti-kickback law if they offer a physician anything of value in exchange for prescribing the manufacturer's product. The goals of the anti-kickback law are avoiding interference with clinical decision-making, preventing overutilization and increased costs, ensuring patient freedom of choice, eliminating competitive harm, and safeguarding patient safety and quality of care. The law seeks to achieve those goals without hindering legitimate, effective business arrangements that promote the public's health. Each violation of the anti-kickback law is a felony, punishable by $25,000 and/or imprisonment for up to 5 years. In addition, civil monetary penalties of up to $50,000 per violation may be imposed. If the same kickback is offered to multiple providers, the government may view each of these offers as separate violations. So, for example, if the same bribe is offered to 50 providers, 50 separate violations will be counted, resulting in multiple fines and civil monetary penalties. In addition, conviction under the anti-kickback statute will result in automatic exclusion from participation in federal health care programs. This means that the convicted individual or entity will no longer be eligible for reimbursement from Medicare or Medicaid. Although the reach of the anti-kickback law was meant to be broad, Congress chose to protect legitimate business arrangements that, without protection, could land both the offeror and offeree in criminal hot water. It did so by including several exceptions in the statute itself, as well as by authorizing the Department of Health and Human Services to create additional regulatory safe harbors. There are now 10 statutory exceptions and 25 regulatory safe harbors. If an arrangement complies with all of the elements of an exception or safe harbor, to the letter, the participants will be protected from liability. Compliance with a safe harbor or exception is an optional mechanism for insulating an arrangement from anti-kickback liability. Failure to comply with an exception or safe harbor does not necessarily mean that the arrangement is unlawful. It simply means that the legality of the arrangement will be assessed on a case-by-case basis. If an arrangement fails to meet every condition of an exception or safe harbor, the government may conduct a facts and circumstances analysis of the arrangement and its effect on federal health care programs and their beneficiaries, and decide not to exercise its enforcement discretion, if it believes the benefit to the public outweighs any potential harm. In 2010, as part of the Affordable Care Act, Congress added an exception that excludes from liability a discount arrangement between a manufacturer and a federal health program beneficiary who is participating in Medicare's coverage gap discount program. In general, drug companies may not offer discounts to Medicare or Medicaid beneficiaries because the discount will be considered a kickback. That is, an impermissible incentive to purchase the company's drug. To alleviate the so-called donut hole coverage gap facing certain Medicare beneficiaries, which is triggered once a certain reimbursement limit is reached, the new exception allows for discounts on certain drugs and removes this otherwise prohibited incentive from anti-kickback liability. The anti-kickback law has been interpreted to prohibit arrangements in which just one purpose of a payment is to induce the referral of federal healthcare business, even if the payments are also motivated by other legitimate purposes. In 2011, the Seventh Circuit Court of Appeals affirmed the one-purpose test for anti-kickback liability, joining several other circuits. In that case, a physician was placed on the payroll of a psychiatric hospital and given false job titles and job descriptions to support a sham arrangement, as part of which he received payments for the referral of patients with whom he had relationships from other business ventures. On appeal from his conviction, the physician argued that the court failed to recognize that he, in fact, performed some bona fide employment services on behalf of the hospital. The appeals court disagreed and held that there was no bona fide employment arrangement, and even if he had performed services and a safe harbor was satisfied, which it was not, if just one purpose of the arrangement was to induce referrals, the arrangement would lose its safe harbor protection and violate the anti-kickback law. In addition to reaffirming the one-purpose test, this case also represents a departure from the common understanding that safe harbor protection would preclude further analysis, cloaking the arrangement with immunity from anti-kickback liability. The effects of this shift should be heeded as a signal that safe harbor protection may not be as foolproof as once believed. In 2012, the OIG similarly engaged in a narrow reading of safe harbor protection in Advisory Opinion 12-06, suggesting the government's willingness to persist in its scrutiny of an arrangement even where it appeared that all elements of a safe harbor were satisfied. In that advisory opinion, although the initial arrangement satisfied a safe harbor, the OIG found that a new ancillary business arrangement must be analyzed under a secondary safe harbor whose elements were not satisfied, thus exposing the entire arrangement to anti-kickback liability. The Affordable Care Act, or ACA, has provided clarification regarding the intent requirement of the anti-kickback statute. Although differing interpretations existed among circuits, a commonly cited Ninth Circuit case, Hanlester v. Shalala, held that a defendant had to knowingly and willfully engage in prohibited conduct with the specific intent to violate the anti-kickback law. The Hanlester decision was controversial, and many other circuits rejected it. However, it was widely cited by defendants seeking to avoid liability by claiming ignorance of the law. The ACA now makes clear that conviction under the anti-kickback law does not require proof that the defendant had actual knowledge of the statute or the specific intent to violate it. This means that Hanlester is no longer good law, and there is no longer any uncertainty regarding whether specific intent to violate the anti-kickback law is required for liability to result. It is not. Although the effect of this development remains to be seen, it appears that establishing liability under the anti-kickback statute just got a little easier for the government. The second notable ACA provision regarding the anti-kickback statute is the codification of the principle that the submission of a reimbursement claim for goods or services provided in violation of the anti-kickback statute constitutes a false claim for purposes of the Federal False Claims Act. Previously, some courts have reached a similar result under the theory that the submission of a reimbursement claim includes an implied certification that other applicable laws, including the anti-kickback statute, have been followed. However, not all courts accepted the implied certification theory. Moreover, some courts refused to extend the theory to situations in which the claim was submitted by a third party who was not involved in the underlying kickback. With the changes in the ACA, these distinctions no longer matter. Any claim resulting from a violation of the anti-kickback law is now grounds for False Claims Act liability, regardless of whether the claims were submitted by the participants in the kickback or by somebody else. There have been several recent examples of the robust enforcement mechanisms in place to combat fraud in the context of the anti-kickback statute. In November 2012, DOJ announced a $30 million settlement with Orthofix International to resolve allegations that one of its subsidiaries paid kickbacks to certain surgeons to induce them to use the company's spinal surgery products in their surgeries. The behavior in question included payments made pursuant to sham consulting agreements, research grants, royalty payments, lavish entertainment and travel expenses, speaking engagements, and seminars. The settlement also included the requirement that Orthofix enter into a 5-year corporate integrity agreement. In September 2009, Pfizer and a predecessor company, Pharmacia, entered into a settlement with DOJ for $2.3 billion, with $49 million paid to resolve anti-kickback allegations. In that instance, the government alleged that Pfizer and Pharmacia provided prohibited remuneration in the form of illegal kickbacks through advisory boards, seminars, speaker training programs, and consultant meetings, as well as lavish travel and accommodations to resorts and payments of honoraria. Pfizer was also required to enter into a 5-year corporate integrity agreement as part of the DOJ settlement.